These are important questions clients ask us. We make light. It probably comes up in most families at some point. When's the right time to talk about it? I'm not sure there's a wrong time.
There's not a wrong time to talk about it. And part of having this conversation, holidays and families in mind, one of our favorite families came up in this conversation, which is
it's a case study of generational interaction, conflict, and the kind of things that happen around holiday gatherings and families at the table. It's the Griswolds.
It's the Griswolds. So we figured we would talk about it in the context of the Griswolds, and specifically Lewis and
Bethany.
Aunt Bethany.
Aunt Bethany.
So, do you remember who Lewis and Aunt Bethany are?
Right. So Lewis and Aunt Bethany are Clark's aunt and uncle. Mm-hmm. And no relation to Ellen or the other side of their family, which also has their own set of peculiar issues. But Clark and Ellen don't see Bethany and Lewis all the time. And
So like holidays only.
and holidays only. And so when that's happening for all of us as we're interacting with family members that we don't see all the time, it brings about some questions, and we get asked those questions as lawyers, and I think you can ask those questions as family members all the time.
We run down their fact pattern. I don't believe Lewis and Bethany drove there.
No, they had to be driven.
I think they live alone. Lewis was in charge. Bethany wrapped up her cat as a gift, and the Jell-O, and so the pledge as the blessing.
Right. So there's certainly some flags.
So, all right, let's talk about it. So the kids and the family members are seeing Bethany.
And Clark is going to be asking some questions the next day.
Call it us. What should we do? What are Clark's options with Bethany? What do you think?
What can Clark do for Bethany? So if Bethany has some estate planning documents in place already, Clark might already be set up, or maybe Clark's father, who's closer to Bethany, will be already set up to take care of Bethany and Lewis if they need to. But if Bethany and Lewis haven't signed estate planning documents, the first question is, are they still capable of signing estate planning documents? Do they have the capacity at their current state to understand and to sign estate planning documents? And maybe Lewis does, maybe Bethany doesn't. So their options might be different depending on how far they have progressed in any type of situations. What would you do for Bethany if she doesn't have the capacity to sign new documents?
So they're in kind of different paths. I don't think Bethany, she probably doesn't have the capacity. She remembers that Grace died 30 years ago, but probably not what's happening right now in this world. So she's more of in Georgia, she's more of a probate court candidate. She's going to fall into a very a formal, people tend to call it expensive. It is on more expensive end. It's formal. It's more difficult, probate court, guardianship, and conservatorship. Guardianship is kind of what it sounds like. A judge rules that you are no longer capable of formally taking care of yourself. That's the guardian. And the conservators, you're no longer formally capable of taking care of your finances. So they take away those rights from you as a person and give them to somebody else, some other family member that petitioned the court to do it.
And they don't have to have both. You can have a guardian and a conservator, or you can have a guardian without a conservator or a conservator without a guardian. It's not necessary that you have both of those put in place with the probate court. They're separate proceedings that oftentimes go hand in hand, but they don't have to.
That's right. But either one of them, they both have judicial oversight. The court will appoint parties to represent the Aunt Bethany in the example, but they will appoint their own lawyer for them. They will appoint a guardian ad litem for them. There's some evaluations that go on with these types of appointments because it's a serious proceeding to remove rights and to decide that you can no longer take care of your finances or your person, whichever or both it may be. It's a more serious proceeding, and that's kind of where Bethany is. Like, you're not working with her, you're now working for her in her best interests. And as you work for her in her best interests as her guardian and or conservator, you're going to have tick marks with the court the whole way through. You're going to have yearly filings. If you want to sell things, you're going to ask the court, am I allowed to do this? You're going to have judicial oversight at every step through the way, all through the way, until the guardianship ends, and that could be with Bethany's death, or if for some reason she is deemed by the court to no longer need it, which doesn't happen often.
Who is the best person to ask to be appointed a conservator or a guardian for an adult incapacitated person?
It's somebody that's going to be close to Bethany. It's also, for a conservator, somebody's going to be able to post bond. You got to have somebody that can get out there and get that insurance policy. So a bond is essentially an insurance policy for all of Bethany's estate, which is her, money in the bank, her assets that she has. You don't have to have an amount of money equal to Bethany's, but you have to be able to get an insurance policy to insure yourself. So it needs to be somebody close to Bethany, preferably somebody that has some knowledge of what she's doing, but also somebody that's able to get bond. Which is funny because the entire flip side of that, if you don't have somebody that can do it, the court will appoint a stranger for you. So,
which is why when we're doing estate planning, we're looking to prevent having to go through that expensive and cumbersome conservator relationship in the probate court proceeding that has to happen in order to be appointed as conservator. And the alternative is, if you can have the planning in place in advance, is to have a power of attorney or a revocable trust in place for a person.
Or both.
Or both, ideally both, as they head towards the time when they might be incapacitated, because that's a much easier way to manage assets for somebody, an elderly relative, for example, who needs assistance. It's less burdensome, there's less reporting requirements.
Can you talk about what you can do management-wise with a trust or a power of attorney? Do trust first.
Sure. Well, with a trust, if assets are titled in the trust first, just having a trust does nothing. The assets have to be actually titled in the trust for the trust and the trustee to be able to function in a way that they can help with a person's management of their assets. So with that, as a trustee, you really have management of assets. You can handle distributions, you can handle the investments, the gifting sometimes can be done as a trustee of a trust. So essentially it's anything financial, except you are not able, using a trust and your role as trustee, to enter into contracts for a person who might have an incapacity. You aren't able to reach assets that aren't titled in the trust. So this is where the trust might cover the investment accounts that are titled in the trust, but you also need to have a power of attorney in place for an incapacitated person in order to reach non-trust assets like retirement accounts, investments that are in IRAs or sometimes in annuities that are qualified, to deal with things like Social Security, to deal with even just payment of bills, credit cards, or anything else that might be personal to the person, not within the name of the trust. Also, dealing with tax issues. You have to have a separate power of attorney relationship. Your trustee can't manage those things, and you as trustee can't manage those things for an incapacitated person. So you're using those documents sort of as a replacement of a conservatorship, but there's still things that you might need to have a conservatorship to put on top of that in certain situations. So I think the important takeaway from this is, if you are seeing relatives and your parents or aunts and uncles, other people where they might start to need assistance with things, there are solutions. And sometimes it's an overlay of multiple different documents or procedures that are going to get you the ability to take care of assets for them. But I think the takeaway is, if you notice something's going on, sooner rather than later is the time to bring up an issue and talk to somebody about what documents they might have in place, or talk to a professional about what documents should be put in place.
At any time that they have, while you still have Uncle Lewis, I think is a great time to talk about these issues before you get to Bethany. Certainly your guardian conservatorship will help Bethany. Right. You can get Bethany help, but it's a lot nicer to, so I feel like with an Uncle Lewis situation, if we were to be his agent under a power of attorney or his trustee, we're working together with Uncle Lewis if he named us. Right. Versus in that Bethany example we were talking about earlier, we're working for her. She's not working with us. She's not allowed to anymore.
Ideally, it needs to happen when you're Ellen and Clark, before you even get to Bethany and Lewis level.
Very true.
Very
true.
But certainly it's easier the sooner you start.
And you and I were talking about that earlier. You do need to do it, when you are Ellen and Clark, because anything could happen at any time.
Correct.
You can't foresee that future.
That's right.
If we want to talk about anything else at that Thanksgiving table, I know people say, like, my mom and I share a bank account.
Right.
Is that a good idea? Because you're not a power, there's no agent under power of attorney, no trust, and no conservatorship there. Is that a way to beat the system?
I think people who treat joint accounts sometimes as a shortcut, a way to help give a child the ability to manage assets for your benefit. But that is a shortcut that sometimes does not pan out to be a good idea, especially if you've got multiple children and you're just picking one to put on that joint account. Now what you've done is you've left assets to one child when your intention is that the assets be split amongst your children.
Right. So at that person's, at one of the two owners' death, it's a winner-take-all situation here. So the survivor takes the whole thing. So if it's a parent and child, and presumably the child survives the parent, the surviving child, it's on their honor to split it with their siblings.
Can create some tax issues, can create some friction among your family where one child is perceived to have been favored. It also is a situation where you're asking a child to, or another, it doesn't necessarily have to be a child obviously, but you're asking another person to use your money for you, but they are under no fiduciary or agency obligation to do that. And if they walk away with the entire contents of that bank account, there's really nothing to stop them. So certainly if you're putting somebody on an account with you, hopefully you trust them, but there are better ways to go about giving someone access to funds to help you or to take care of you than making a joint account with them, which just opens you up to a lot of longer term problems. What about children? I mean, you're going to be seeing your children, they're going to be showing up, your kids are going to be coming, maybe they've got your grandkids with them, or your children are showing up with their partners and significant others. Is that a good time, you think, to bring up whether they have estate planning and what should be done for their estate planning?
First of all, these questions might be floating around that younger generation's head anyway. It's always a good idea to tell your younger generations about your own plan, which sort of opens the door and creates the opportunity to ask them about their plans, which, so I just said a minute ago, you never know what's going to happen even with Ellen and Clark. I've already talked about the guardian and conservatorship aspect with Aunt Bethany, but I've seen a lot of guardianships and conservatorships created for young adults because there's a lot of chance out there in this world. So you really cannot start planning too young.
And they may not need a will, they may not need anything elaborate, but younger people, and here I'm talking about anybody over the age of 18, really should have a financial power of attorney, and they should have an assisted, they should have a financial power of attorney, and they should have an advance directive for health care. And those are the base documents that everyone over the age of 18 should have.
And they're not terribly difficult to put in place. They're not overly cumbersome for your 20-year-old to sit down and do.
Right. And when I'm talking with a client and they're asking, what about my older children? So again, we're talking about children who may now have families of their own, children of their own. I get a lot of my clients who are concerned whether their children are engaging in the kind of planning that they are doing for themselves. And the answer for them is, of course, that's up to your children to do, but if you want to raise the issue with them because you've been through it and want to talk to them about the documents they have or should have, at a minimum, they should have documents that provide for guardianship for their children, your grandchildren. That's always a concern. And again, just like everyone, it's proactive to have documents put in place that are going to make things easier for the people that are going to have to take care of things if something happens. There's no mystery.
Everybody loves instructions.
Right. There's no mystery. Something's going to happen to all of us at some point. We don't know when it's going to be. Not having documents in place does not mean that that will not happen. It just means it's going to be harder for the people that are going to have to take care of things for you. So we're big proponents of making it easier for the family that might have to do things. So again, and these are topics you probably don't want to discuss at your holiday table. It's going to be a real downer.
Right.
But if you want to think about them and bring them up another time.
If you're thinking about them at the holiday meal, you can talk about it a week or two after.
Right, right. It may come to mind. I don't suggest you necessarily talk about it over pumpkin pie, but
you might think about it there.
But these are important questions clients ask us. We make light. It probably comes up in most families at some point. When's the right time to talk about it? I'm not sure there's a wrong
There's not
time.
a wrong time to talk about it. It's when you're keeping it secret is probably the worst idea.
Right.
So
That's
find the
right.
right time and do it.
That's right.
You know.
Share your information. Talk openly with your children about their planning and their information. All of that makes things a lot easier when the time comes and something does happen. There's much less likelihood of friction.
Exactly. Well,
cheers.
Good luck out there.
Good
Cheers.
luck.